In 2021, a buyer in a suburb outside Denver got cold feet 9 days before closing, walked away from the deal, and by the time the lawsuits, the broker commissions, and the resale gap were finally settled 2 years later, he owed the sellers just under $140,000. More than the entire Earnest money deposit, more than his down payment, more than the car in his driveway was worth. He didn't lose a house, he lost a court case about a house he never even lived in. Welcome to Catastrophe Theory, where we figure out exactly how fast your life falls apart if you actually let the intrusive thoughts win. I'm CJ Theory, and today we're looking at what happens when you stand in the kitchen of a house you just agreed to buy, keys practically close enough to smell, and quietly think, I don't want this anymore. What if I just didn't? You are standing in that kitchen right now. Let's put you there properly. It's 10 days before closing. The house still smells like someone else's life, a faint trace of cooking oil baked into the cabinets, fresh paint over a wall patch near the stairs, carpet that's been vacuumed in tidy little lines for the open house months ago. Your footsteps sound too loud on the hardwood, the way footsteps always do in a house that isn't yours yet, and might not be your house at all depending on what you do in the next 10 minutes. There's a manila folder in your hand, thick with paper, heavier than it has any right to be for something made of nothing but ink and promises. Somewhere behind you, your real estate agent is on the phone with the title company, using words like escrow and clear to close, in a tone that suggests this is all routine, all fine, nothing to think twice about. But you are thinking twice about it. Maybe it's the inspection report sitting in that folder, the one with more yellow highlighter than white space left on the page. Maybe it's the mortgage payment number that looked smaller on a spreadsheet than it does typed out in an actual loan document, with your actual signature under it. Maybe it's nothing you can name at all, just a cold, specific dread crawling up the back of your neck, the kind that shows up uninvited at the worst possible moment, like a smoke alarm going off over toast. Your hand hovers over the folder. Somewhere in there is a phone number for your agent, your lender, your attorney if you were smart enough to hire one, and somewhere in the back of your mind is a single, quiet, catastrophic thought. What if I just walked away right now? That thought is not crazy. It is statistically an extremely common thought. Somewhere between 5 and 15% of home purchase agreements in the United States fall apart before closing in any given year, depending on the market conditions, meaning you are far from alone in that kitchen, holding that folder, having that exact thought at that exact moment. But common doesn't mean cheap. And it definitely doesn't mean simple. What happens next depends entirely on paperwork you probably skimmed, deadlines you probably didn't circle in red, and a legal machine that was built quietly and deliberately to make sure that walking away from a signed contract is never as easy as just walking away. I've spent a long time investigating exactly what happens in that kitchen, not as a real estate agent, not as a lawyer, but as someone who sat across from people living through the aftermath, going through the timelines, the emails, the 4 a.m. panic Googling that led absolutely nowhere useful. I've read the contracts nobody reads. I've watched what happens when the thought wins. And I'm going to walk you through the entire mechanical anatomy of that decision, piece by piece, so that if you're ever standing in that kitchen yourself, you're not standing there guessing. Because here's the uncomfortable truth underneath all of it. A real estate contract isn't a suggestion. It isn't a soft agreement you can quietly step back from with an apologetic phone call and a shrug. It's one of the most binding, enforceable financial documents most people will ever sign in their entire lives, arguably more binding than most people's marriage vows, and certainly more expensive to break. So let's take it apart. Let's start at the very beginning, back before that kitchen moment. Back at the part almost nobody thinks about carefully enough, the signature itself. When you sign a purchase agreement, you're not signing a form. You're entering into what's called a bilateral contract, meaning both sides, you and the seller, are making binding promises to each other. The seller promises to sell, you promise to buy. And attached to your promise, almost immediately, is a very specific, very real sum of money called earnest money, sometimes called a good faith deposit, typically somewhere between 1 and 3% of the purchase price, though in competitive markets it can run higher. On a $400,000 home, that's commonly somewhere between $4,000 and $12,000 sitting in an escrow account waiting. Here's the mechanical reality worth understanding. That money isn't a fee. It isn't rent for the privilege of considering the house. It's collateral. It's the financial version of a security guard standing at the door of the deal, there specifically to make sure you don't walk away without consequence. Think of the entire contract as a piece of engineering, a suspension bridge with cables running in both directions. The seller has taken their house off the market, often turning down other interested buyers, sometimes for weeks. In exchange, you've put real money on the line to prove you're serious. Pull one side of that bridge without warning, and the whole structure doesn't just gently deflate, it swings hard in the other direction. But, and this is the part that deserves real attention, the contract isn't designed to be a trap with no exits. It's designed with specific negotiated doors built into it, called contingencies. And understanding exactly how those doors work is the single most important financial self-defense in this entire situation. Let's go through them because this is where most of the real protection and most of the real danger actually lives. The first major contingency is the inspection contingency. This gives you a defined window, often somewhere between 7 and 14 days depending on your contract and your state, to have the home professionally inspected and, if serious issues are found, to renegotiate, request repairs, or in many cases walk away entirely with your earnest money fully protected. This window exists because you cannot possibly know everything about a house from an open house walkthrough with strangers' furniture in every room. It exists because foundations crack quietly, because roofs age invisibly from the outside, because knob and tube wiring behind drywall doesn't announce itself. The second major contingency is the financing contingency, sometimes called a mortgage contingency. This protects you if, despite your best efforts, your loan falls through, if the lender's underwriting reveals something that changes your approval, if interest rates shift the math beyond what you can support, if your financial situation changes unexpectedly during the process. Without this contingency in place, walking away because your loan didn't come through isn't a protected exit, it's a breach, exactly the same as walking away for any other reason. The third is the appraisal contingency, which protects you if the home is professionally appraised for less than the agreed purchase price, a real and fairly common scenario, especially in fast-moving markets where offers get pushed above asking price in bidding wars. Without an appraisal contingency, if the home appraises low, you're often still on the hook to make up that gap in cash or lose your deposit trying to back out. And there are others. A title contingency, protecting you if the property's legal ownership history turns out to be a mess. Sometimes a home sale contingency, protecting buyers who need to sell their current home first. Occasionally an attorney review period, common in certain states, giving a licensed attorney a short window to review and potentially cancel the contract on legal grounds shortly after signing. Here's the mechanism you need to actually internalize. Each of these contingencies is a legally defined escape hatch with a legally defined deadline. Walk through that hatch before the deadline closes, following the specific written procedure your contract requires, and you can typically back out with your earnest money protected and returned. Miss that deadline, even by a single day, and the hatch doesn't just get harder to open. In most contracts, it seals completely, permanently for the rest of the transaction. This is the part almost nobody explains clearly enough, so let's slow down here, because this single mechanical detail is responsible for more lost deposits than almost anything else in residential real estate. Contingency deadlines are not soft suggestions. Many contracts include language making time of the essence, a specific legal phrase meaning deadlines are treated as strict, material terms of the agreement, not flexible guidelines open to interpretation. Miss your inspection contingency deadline by 2 days because you were waiting on a scheduling conflict with your inspector, and in many contracts, that contingency has now expired. The door didn't slowly close. It was on a timer, and the timer ran out while you weren't looking. So where does that leave you? Standing in that kitchen 10 days before closing, past every contingency deadline, holding a report with too much yellow highlighter and a feeling in your gut you can't quite name. You're standing past the escape hatches, which means the next part of this story is about what happens when the bridge actually gets pulled. Let's walk through the timeline of consequences, because this is where the real financial chaos begins to unfold, and it unfolds in stages, not all at once, which is exactly why so many buyers underestimate it until it's already happening to them. Stage 1 is the earnest money forfeiture. If you walk away outside your contingency windows without a legally protected reason, the seller is typically entitled to keep your earnest money deposit. In many contracts, this is structured as a liquidated damages clause, a pre-agreed amount decided back when you signed, representing the seller's estimated damages for the deal falling apart. On paper, this can sound almost clean, almost final. Lose the deposit, walk away, chalk it up to an expensive lesson. But here's the twist that catches people completely off guard. In a meaningful number of contracts, especially ones without a clearly capped liquidated damages clause, earnest money forfeiture is not the ceiling of your liability. It's the floor, which brings us to stage 2, and this is where the story stops being about a deposit and starts being about a lawsuit. If a seller's actual damages exceed the earnest money you forfeited, many contracts allow the seller to pursue you for the difference. What counts as damages? This is where it gets genuinely brutal and genuinely underexplained by most people giving casual advice on the internet. If the seller has to relist the home and eventually sells it for less than your original agreed price, you can potentially be on the hook for that price gap. If the home sits on the market for months while carrying costs accumulate, mortgage payments on a home they were trying to leave, property taxes, insurance, HOA fees, utilities to keep pipes from freezing in an empty house, those carrying costs can, in some cases, be added to what you owe. Real estate commission on the failed deal, sometimes never refunded, sometimes rolled into the claim against you. Legal fees for pursuing the claim in the first place, which many contracts explicitly allow the prevailing party to recover. Stack all of that together, and that Denver buyer's $140,000 outcome stops sounding like an outlier and starts sounding like a mechanical, predictable result of a deal that fell apart at the wrong moment in a softening market without the right contingencies in place. And there's a third stage, rarer but real enough to understand: specific performance. In some jurisdictions and some contracts, instead of simply suing for money damages, a seller can ask a court to force the sale to actually go through, compelling you to buy the house anyway on the original terms, whether you want it or not. Courts don't grant this automatically, and it's used less often than damages claims because it's a more complex legal remedy. But real property contracts are one of the few areas of contract law where courts have historically been willing to grant it, specifically because real property is considered legally unique. There is, quite literally, no other house exactly like that house, which is part of the reasoning courts have used to justify forcing the sale through rather than simply awarding money. So what actually happened, mechanically, in that Denver case? He missed his inspection contingency deadline by a wide margin, backed out over financing concerns without a properly protected financing contingency in place, forfeited a modest earnest money deposit almost immediately, and then watched as the sellers, who'd already lined up their own next home purchase based on his expected closing date, relisted in a market that had cooled by nearly 8% in the time it took to find a new buyer. The math wasn't emotional, it was arithmetic. Purchase price gap plus carrying costs across a longer listing period, plus legal fees, minus the earnest money already forfeited, equals a debt that followed him long after he'd stopped thinking about that house at all. Here's a question worth sitting with for a second. If the system is genuinely built with escape hatches, contingencies, protected windows to walk away safely, why do so many people end up on the wrong side of that door anyway? The honest answer is almost never malice or recklessness. It's usually something much smaller and far more human. A deadline calendar that never got built, a verbal agreement with an agent that was never put in writing, a contingency waived under pressure during a competitive bidding war because everyone else is waiving theirs too. The mechanism that protects you only works if you actually use it, on time, in writing, exactly as your specific contract requires. And that's a detail that gets lost constantly in the emotional chaos of buying a home. Because nobody signs a purchase agreement while thinking clearly about worst-case exit scenarios. You sign it while thinking about paint colors and moving trucks. Which brings us to something almost nobody talks about tucked quietly inside all of this: your credit and your next mortgage application. Backing out of a purchase agreement doesn't directly appear on your credit report the way a missed payment would, but the financial fallout absolutely can. A specific performance judgment against you or a damages judgment you fail to pay can become a matter of public record, potentially a lien, potentially something a future lender's underwriting process turns up when you try to buy a different home 18 months later, wondering why your file suddenly looks more complicated than it should. And there's a second, quieter cost that almost never gets discussed at all: the seller's story running in parallel to yours the entire time. While you're standing in that kitchen weighing your own dread, somewhere else, a family who accepted your offer has often already given notice on their rental or accepted an offer on their own home with a contingency built around your closing date, or started packing boxes based on a date now sitting on your contract in ink. When a deal collapses, it rarely collapses in isolation. It ripples sideways into someone else's timeline, someone else's plans, someone else's stress, which is worth remembering with real empathy before assuming the only person affected by that walkaway decision is the person making it. Before we get to what you can actually do about all of this, let's clear out some of the noise, because this is a topic absolutely buried under confident-sounding, dangerously incomplete advice. Myth 1: I can always get my earnest money back if I simply change my mind. Reality: this is false, and it might be the single most expensive misconception in residential real estate. Why it's false? Earnest money is specifically structured as a demonstration of serious commitment, protected for the buyer only within contingency windows or under specific contract-defined conditions. Once those windows close, "I changed my mind" is not, on its own, a protected reason. It's a breach. The money doesn't wait around to see if you're sure. It transfers to the seller, often automatically once the contractual conditions for release are met. Myth 2: worst case, I just lose my deposit and that's the end of it. Reality: also false, and dangerously so, because it stops people from taking the situation seriously enough, early enough. Why it's false? As we walked through, earnest money is frequently a floor, not a ceiling. Sellers in many jurisdictions retain the right to pursue additional damages, additional legal fees, and in some circumstances, specific performance well beyond whatever was sitting in that escrow account. Myth 3: if the seller finds a new buyer quickly, I'm automatically off the hook. Reality: false, and this one is subtle enough to deserve real explanation. Why it's false? A quick resale can genuinely reduce a seller's damages, sometimes down close to zero, which is good news in the sense that it limits exposure, but it doesn't retroactively erase the breach itself, and depending on the contract's specific liquidated damages clause, the seller may still be contractually entitled to keep the earnest money regardless of how quickly they resold, because that clause was often written specifically to avoid the need to calculate exact damages case by case in the first place. Myth 4: Verbal reassurance from my agent or the seller's agent is as good as a written contract amendment. Reality, false. And this is where a huge number of good faith, well-intentioned buyers get burned. Why it's false? Real estate contracts in the vast majority of jurisdictions require written amendments to modify agreed terms, deadlines, or contingencies. A friendly phone call where someone says, "Don't worry about the inspection deadline, we're not in a rush," can feel completely reassuring in the moment and carry precisely zero legal weight if that seller later decides to enforce the original written deadline instead. If it isn't in writing, in most cases, it functionally didn't happen. So, knowing all of that, knowing the mechanism, knowing exactly how the bridge gets pulled and what happens when it does, what can you actually do? How do you turn that kitchen floor dread into something closer to control? Here's your framework. 10 specific concrete things, whether you're standing at the very beginning of this process or already deep inside it, folder in hand, deadline looming. 1. Before you ever sign anything, read every single contingency deadline in the contract and put them on an actual calendar with reminders days in advance of each one, not mentally, not "I'll remember," but written down somewhere you'll actually see it. The single biggest cause of lost protection isn't bad luck, it's a missed date nobody was tracking. 2. Hire a real estate attorney to review the contract before you sign if your state allows it, and especially if it isn't automatically included in your process. In many regions, this costs a few $100s, a genuinely small amount compared to the tens of thousands of dollars a poorly understood clause can cost you later. 3. Never waive a contingency casually, even under competitive pressure. If you're being pushed to waive your inspection or financing contingency to make your offer more attractive, understand precisely what door you're closing and weigh that against how much financial cushion you actually have if things go wrong. 4. If you're inside a contingency period and you have real doubts, don't sit on them. Move quickly, formally, and in writing through the exact cancellation procedure your specific contract requires, which might mean a specific form, a specific notice period, a specific method of delivery like certified mail or a formal email through your agent. "I told my agent I wanted out" is not the same as "I formally canceled according to contract section 14 subsection 2. 5. Get everything in writing. Always, no exceptions. Every extension, every agreement to adjust a deadline, every reassurance from the seller's side. If it isn't a signed, written amendment, treat it as though it doesn't exist, because legally, in most cases, it doesn't. 6. If you're past your contingency windows and seriously considering backing out anyway, consult a real estate attorney before you do anything else, before you call your agent, before you tell the seller, before you do a single thing. Understanding your specific state's laws and your specific contract's liquidated damages clause before you act can be the difference between a $5,000 mistake and a five-figure one. 7. Consider negotiating a mutual release instead of a unilateral walkaway. In some situations, sellers genuinely prefer a clean, cooperative exit, especially if they suspect a reluctant buyer might cause problems during closing anyway, and are willing to negotiate a reduced forfeiture or a full release in exchange for a fast, drama-free resolution. This isn't guaranteed, but it's worth exploring before assuming your only options are close or get sued. 8. Understand your specific state's laws around earnest money caps and liquidated damages because they vary meaningfully. Some states cap how much a seller can retain as liquidated damages relative to the purchase price. Knowing your specific state's rules before you're in crisis mode changes the entire conversation. 9. If your reason for backing out involves financing, inspection findings, or appraisal, the situation's contingencies exist specifically to protect. Make absolutely sure you've documented the underlying issue properly. A denied loan needs an actual denial letter from the lender. A serious inspection finding needs the actual inspection report submitted through the proper channel before your deadline. Vague discomfort isn't the same as a documented, contract-recognized reason, even when the underlying feeling is completely legitimate. 10. Keep a written record of every communication throughout the entire process, emails, texts, formal notices, because if this situation does escalate into a dispute, that paper trail becomes the actual evidence determining what you're liable for and what you're not. Memory is unreliable. Timestamps are not. Now, after all of that, after the Denver number, after the liquidated damages clauses and the specific performance courts and the 10-point checklist, I want to pull back because there's something important buried underneath all this fear, and it deserves real space. None of this machinery exists to trap you. It exists because buying a home is one of the largest, most consequential financial and emotional commitments most people will ever make, involving two sides, a buyer and a seller, each rearranging their entire lives around a shared promise. The contingency periods, the earnest money, the written deadlines, these aren't obstacles designed against you. They're the engineering that makes it possible for strangers to trust each other with hundreds of thousands of dollars and an entire chapter of their lives, without needing to personally know or trust one another at all. That's not a small thing. That's actually kind of remarkable if you step back far enough to see it. The dread you might feel standing in that kitchen isn't a malfunction. It's a completely normal human response to a genuinely enormous decision, arguably one of the most consequential financial signatures most people will ever produce in their entire lives. Validating that fear matters because pretending it's irrational doesn't make it disappear. It just makes people feel foolish for having it in the first place right before they make a rushed, poorly informed decision because they were too embarrassed to slow down and ask questions. But here's the reframe, and it's the one I actually want you to leave with. The fear doesn't need to be eliminated. It needs to be met with information early enough to actually matter. A buyer who reads every contingency deadline the week they sign, who keeps a calendar, who knows exactly which doors are open and which ones have already closed, that buyer can feel every bit of that kitchen floor dread and still make a clear-eyed, financially protected decision instead of a panicked one. The goal was never to feel nothing. The goal is to feel prepared enough that the intrusive thought, "What if I just walked away?" becomes a question you can actually answer, calmly, with real numbers, instead of a spiral you fall into at 11 at night with a contract you never fully read. Because underneath the catastrophe, underneath the $140,000 cautionary tale, this is still fundamentally a story about people trying to build ordinary lives. A kitchen that eventually smells like your own cooking instead of someone else's. A hallway with your own photographs instead of blank patched drywall. A mortgage payment that becomes just another quiet Tuesday instead of a source of dread. That ordinary life is worth protecting properly, with the right information, at the right moment, so that when you're finally standing in that kitchen, whichever side of the deal you end up on, the only thing you're feeling is the actual, uncomplicated relief of coming home. But that's just a theory, a catastrophe theory. Thanks for not ruining your life.